Hi, this is session 4.1, dealing with children and divorce. It is important to remember that no court will grant any order for divorce unless the interest of the children are taken into account. So what interests are these that the court will look at? The first thing is joint rights and responsibilities. You may remember that in the old days we used to call that sole custody, sole care, guardianship, contact, access, but the new act calls it joint rights and responsibilities. The next aspect is the question of primary residence. Who will the children live with after the divorce, and that person will be responsible for the day-to-day upbringing of the child. The next aspect is the question of maintenance. Joint rights and responsibilities, to break it up, will be contact rights of each parent, guardianship rights, and I will go into detail on each of these aspects in a short moment. But let's just focus on maintenance for a little bit. There are three parts to maintenance. The first part is maintenance as we know it, general term, where a party pays a certain amount each month towards maintenance for the child. This excludes the aspect of educational costs, which needs to be taken into account separately, and medical costs. All three aspects need to be considered when looking at the aspect of maintenance in a divorce before a court will grant any decree of divorce. Now, many of you may know that the maintenance court is tasked with actually resolving these costs or amounts. But the divorce court can also make a decision after hearing evidence from both parties as to the needs of the children and ability. I will discuss this in a later session so we can focus on other aspects of the divorce more in detail. Let's focus on the not so complicated one, being primary residence. Primary residence is who will the children live with after the divorce, going to school, day-to-day care, packing lunch, sleeping, bedtime routine. That's the primary caregiver or the primary resident parent. The person who does not have primary resident is the person who will have contact. And contact in law is normally alternate weekends and half of long school holidays. This means the person who does not have primary residence will have rights of contact. Guardianship is a right given to both parents by virtue of their parental status. This means being able to consent to hospital procedures, passports, as well as school documents and changes, and marriage if they are underage. So when we talk about contact, that is different to guardianship rights, and that requires a joint decision by both parties. Any deviation from these standard terms will require a family advocate recommendation. The family advocate recommendation is where the parties can't reach decision or seek a decision different to the usual decision. And often when there's child abuse, neglect, then the family advocate steps in and makes a recommendation after interviewing all concerned parties, and that recommendation is supplied to the court, who then uses that recommendation to make an order insofar as the children are concerned. So when we talk about children and divorce, the important parts to be considered are those three elements. And if a settlement agreement encapsulates all of these components, the settlement agreement will still need to be endorsed by the family advocate before the court will accept it. Imagine a party being able to just give away his children to the detriment of the children's best interests, and the court just allows it to proceed. That's why the family advocate acts as the upper guardian of children's rights and endorses the agreement to assist the court make a fair finding after the family advocate conducts the interviews. This, in a nutshell, is children and divorce.